name's Ian Hull, and I have the privilege of chairing this panel discussion. A panel discussion with a group that is well known to most of us, but I will take a moment to introduce the speakers and talk a little bit about the subject matter we're going to deal with. So speaking first, I think is the order that we're going in is this as well too, but Marshall Swadron of Swadron Associates. Marshall is practices in the area of capacity law intensely and is well known to many of us at the bar as a real leader and thought leader in the area of capacity law. Does estate litigation as well and has a fantastic group of lawyers there who all support and work in this area of the law. So Marshall's going to, I think, going to start the discussion. We're going to go in this order. Craig Vanderzee from Torque and Mains is our next speaker, and Craig is, again, one of the leaders at the bar, certified specialist of Law Society of Upper Canada, has been deeply involved with the Ontario Bar Association and STEP and the Law Society, a frequent speaker at these events, does a fantastic job as an estate mediator as well, and has a very wide depth of knowledge in the area of capacity law and the topics that we're going to talk about today. Finally, Albert Oosterhoff, Professor Oosterhoff, who it's a thrill always to have him at any event, and a thrill to have him on this panel, who Professor Oosterhoff, who is now Professor Emeritus at the University of Western Ontario, and is continuing to write endlessly and tremendously with regard to the area of estates and trust law. He's never slows down. Made the commute in from Burlington, Ontario by subway, TTC, and by transit across the Great Divide of the Gardiner Expressway, and it's been really, we're going to have a great opportunity to hear from some of his thoughts. I think we're going to be breaking it down a little bit through the analysis of the discussion, through the statute, looking at the cases, and coming up with some conclusions that hopefully will help guide us in what is the not typical, but difficult area, and what of this, and we've been talking about it briefly, and Jordy in his panel just touched on it right at the end as well. We're going to look at a review of the court's role under the Healthcare and Consent Act when the Consent and Capacity Board finds that the end-of-life wishes expressed by an adult person are insufficiently specific to the applicable circumstances. And then, if that's the case, then the best interests of the patient's test governs. So looking at this question at the capacity, consent and post-capacity board level and looking at how the courts are dealing with, I think Marshall was going to start off in giving us a little background on the statutory framework we're looking at in what is a tremendously difficult circumstance for many families.
Thank you very much, Ian, and I very much appreciate the opportunity to speak today. I also wanted to thank the co-author of my paper, Karen Stewart. I'm going to speak about the Healthcare Consent Act and the Consent and Capacity Board. Now, if you appreciate what happened in the Rizzulli case, is that the family expected that the doctor disagreeing with the substitute decision maker in that case would simply apply to the Consent and Capacity Board, and that matters would be determined at the initiation of the doctor with the family members as respondents in seeking to pursue a particular course of continued treatment. In the particular circumstance of that case, it didn't go that way. As we heard, the family was given a deadline by which they were required to make an application to the Superior Court. So what I'm going to talk about is how the Healthcare Consent Act works, and then how, had the case gone through the usual process, it would have ended up before the Consent and Capacity Board, and what the issues before the board would be, and how. Then we'll get into how the board has dealt with some of these cases, and I'll let my co-panelists talk about how the courts dealt with what the board's decisions were in those cases. So I'm going to start first talking about the Healthcare Consent Act. It's a piece of legislation that's relatively new. It's from 1996, and that's part of the name of the act. It's easy to remember, therefore. The act is the first, well, it follows a piece of legislation that was in effect for a year before it was enacted. that is of general application. We have had legislation with respect to substitute decision-making and how to make treatment decisions in the area of psychiatry in particular since 1978. So there were amendments to the Mental Health Act one generation earlier that dealt with the issue of how to make decisions for psychiatric patients who were admitted and were not capable of making their own decisions, and what factors should be brought into play. And if you now look at the composition of cases that are coming before the Consent and Capacity Board, the vast majority of the decisions that it is asked to make relate to inpatient psychiatry, not end-of-life decisions. A statistic that I've seen recently is that although it is a growing area of decision-making for the board, that it would weigh in on decisions of what's in someone's best interest or whether someone had a prior capable wish in the context of end-of-life, it's still about 1% of the business of the board. So when we look at some of the history of the board's role in its jurisdiction and whether this legislation where a doctor can challenge whether a substitute decision maker is acting in best interest, almost all of the prior cases come up certainly before the 2000s, come up in the context of psychiatry. So we start with the legislation purpose, and it has a purposes section, which is very helpful. One of the first purpose is to have legislation that is applicable across all circumstances. So it's not just in the context of psychiatry. Then there is a purpose of enhancing autonomy so that people who have prior capable wishes can expect that those capable wishes will be respected. And then it asks that there be a significant role for family members in circumstances where someone is not capable. And then finally, the state, in the form of the public guardian and trustee, is only to make decisions in cases of last resort. So treatment is defined very broadly, and that was one of the very significant issues in the Razzouli case, which is whether the withdrawal of treatment was in fact treatment. The Supreme Court of Canada found that for reasons, as Harry Underwood told us, that relate to the fact that it involves touching, and then also the fact that they're touching for a therapeutic purpose, even if one was to withdraw mechanical ventilation, but also if one looks through the scheme of the Act, it's intended to have very broad application. In fact, it's even intended to apply where the legislation would not necessarily cover something, but the health practitioner decides to use the Healthcare Consent Act and the process in it. So it comes it's intended to have as broad as possible application with just a list of excluded acts. The Act itself provides for a test of capacity, and it's a pretty universal test. It provides that the test for capacity fluctuates with respect to treatments, so someone may be capable in respect of one treatment and not another, and over time, so that someone may be capable at one time and not another time. And then when someone is incapable, there's a hierarchy of substitute decision makers. So we talked about the fact that Hassan Razzouli's wife, she was not appointed by a power of attorney for personal care, but she was nonetheless a substitute decision maker, and that's because the Act in Section 20 provides a hierarchy. So we start with court-appointed guardians, then we have attorneys under the power of attorney for personal care. Next, we have a board-appointed representative, because the Consent and Capacity Board can appoint a representative. Then we come to spouse, then parent or child, then we get to siblings, then any other family member, and then finally at the very bottom, we get to the public guardian and trustee as, again, a decision maker of last resort. If there is if there's a disagreement between decision makers of the same level, then we also go to the public guardian and trustee. When the decisions are being made in respect of treatment, the substitute decision maker is entitled to the same information that a person who would be making a decision for themselves is entitled to. And there is a test for what constitutes informed consent in Section 11. So now we get to the meat of the Act. And this is when there is an important decision to be made, and there's a meeting between sometimes social workers, sometimes ethicists, also, of course, physicians, and there is a treatment proposed or a proposal that a treatment be withdrawn, which of course is also a treatment decision. And at that stage, it's very important that a substitute decision maker know what they're obliged to apply. And that is the test in Section 21 of the Act. Section 21 establishes the primacy of prior capable wishes that are applicable to the treatment decision. It then establishes that in the absence of prior capable wishes, there's a best interest test. And as I've set out in the paper, this is where I suggest the state is fulfilling a form of parens patriae. That means the obligation of the state as parent to make sure that vulnerable people's decisions are made in accordance with their best interests. And in deciding and defining the best interest test, however, there are what I'll call two aspects that really relate to the person, and then the third aspect, although it's the longest part of the test, that relates to what the expected outcomes of the treatment are. And those are what I'll call the more medical type considerations. So if we look at the first branch of the best interest test, is the values and beliefs of the person held when capable that they would still act on if capable. So of course that is an opportunity to take all of the different things that might not be clear prior capable wishes applicable to the circumstances, but bring that in. So you'd have the opportunity to look at their values and beliefs that way. And it comes a second way too. In other words, things that fall short of binding prior capable wishes also come in the next branch, which is wishes of the incapable person that do not meet the test of prior capable wish under the Act. And those could be the wishes that are expressed by the person while incapable. In other words, even though they're incapable, what are their wishes now? Or any of the other wishes that didn't quite meet the threshold. In other words, they weren't precisely applicable to the circumstances, or they simply were general and not specific. So then we get to the medical part, and it talks about the benefits of the proposed treatment and the costs, whether it will improve someone's condition or their well-being, whether it will improve or whether it will prevent deterioration of a condition, and whether it will slow deterioration. What will happen in the event that the treatment is not given? So you look at the other side, what happens if we continue the status quo? And then we look at the risks and benefits, and then whether there's any less restrictive or intrusive option that would do as well as the proposed treatment. So that is the test, and that's what ensures that best interests are followed. And now here's the enforcement mechanism. In Section 37 of the Act, there is provision for the health practitioner to make application to the Consent and Capacity Board for a determination as to whether the substitute decision maker is acting in accordance with the best interests. Well, actually not just the best interests, whether the substitute decision maker is complying with that Section 21, whether they're following the prior capable wishes, or whether they're following the best interest test in the absence of prior capable wishes. And that's where the Consent and Capacity Board comes in. There's evidence, there's opportunity for the appointment of counsel under Section 81 of the Act for the alleged incapable person. There's even a determination that's deemed and the board must undertake to decide whether the person is in fact capable of making their own decision. And I've of course seen cases where in deciding over what decision should be made, the board reaches the conclusion, well, this person can make it for themselves. They don't have to have a substitute decision maker making it. So the whole process happens very quickly, 7 days from the time of application to the board to when the board must sit. I've seen cases that have gone the day of the application where there's a particularly sensitive, time-sensitive decision, sometimes with respect to blood transfusions, the consequences of which might be loss of life. These cases can go through the night. They take place, in most cases, right in the hospital. So you have a very nimble and somewhat specialized board. So we have a lawyer that leads the panel. We have a physician, usually a psychiatrist, and I'll say that again. It takes its history from the history of the board, mainly dealing with psychiatric decisions, and then a community member. It can sit alone with a single senior lawyer member. So what we have is an opportunity for the decisions to be made with real evidence, with someone having their say, without having to prepare the affidavits that would have to be prepared in that court application seeking the injunction. So it's less costly, it's accessible because the burden is on the doctor to bring the application, and it's speedy. So that's the context in which these cases occur, and I think I've hopefully set the table for the next speakers.
Thanks so much, Marshall. All right, Craig, so we have the statutory framework. What about how's the court's been playing with it?
Well, I've been asked to speak on the case of Scardoni and Hajra, and that's a 2004 decision of the Honorable Mr. Justice Cullity, wherein he considered an appeal by the substitute decision makers from a board decision. And in that particular case, the board had ordered, that is directed, the substitute decision makers to consent to a proposal put forward by the doctors in the case that treatment be withdrawn. So it's a little bit convoluted because it's different than other cases in the sense of is treatment being withdrawn? The actual question before the board was directing the actual substitute decision makers to consent to the withdrawal. And it was on that basis or that decision that was appealed to Justice Cullity. Justice Cullity, in a number of different places in his decision, recognized the difficulty of these kinds of cases. And indeed, in my paper, I set out a couple of the quotes that he used, and he found, as did the board, that everybody was acting in what they perceived to be good faith. There wasn't an issue or an allegation before the board or before the court that either the doctors had some sort of purpose that wasn't absolutely intended to be in the best interests of Ms. Holland in this case, who's the patient, and likewise for her substitute decision makers, who were her two daughters. So it wasn't adversarial in the sense that one side was trying to beat the other. Both sides were trying to do what was best from their perspectives with respect to Mrs. Holland, the patient. So, touching upon the facts, Mrs. Holland in 2003 was 81. She was suffering from advanced Alzheimer's disease, which had, at that point, a debilitating impact on her life. She had lost the ability to speak. Her cognition was greatly impaired, and she was generally unresponsive to stimuli. However, which was different than some other cases, she was not in a coma, nor was she in a vegetative state. And while the substitute decision makers, again, her daughters and the medical staff, disagreed as to exactly what her medical state was, they didn't disagree on the fact that she did not have the ability to make decisions regarding her personal care at this point in her life. So that was not a decision that had to be dealt with, but Marshall referred to could be dealt with in some types of cases. She was first diagnosed in 2001, but in 1998 she had done a power of attorney for personal care, naming both of her daughters, Patricia Scardoni, and that's hence the name Scardoni in the case, and her other daughter, Margaret Holland. The power of attorney, and this touches upon some of the other discussions that have already been had this morning, relating to the thought that people want to put towards their power of attorney for personal care and the making of their wishes known before someone has a situation where they're not in a position to make those decisions or at least convey those decisions in any way. This particular personal care power of attorney made no reference to end-of-life treatment decisions and also did not anticipate the specific condition that she would be having. And that's important as it relates to Section 21 and some of the circumstances that dealing with wishes of a patient that Marshall had talked about. In 2003, Ms. Holland needed to be admitted into the ICU. She was aspirating, and without getting into the medical aspect of that, it's a condition that leads to moisture or swallowing into the lungs rather than the stomach. And as a result of that condition, she was also having infections and severe painful bed sores, which were prone to infection. And as well, as a result of that and having to go into ICU, she had to be placed on a ventilator to assist her breathing. She underwent a tracheotomy and then was fed through her stomach. And it's important with some of these cases to understand the differences in the medical statuses of some of these patients, because I do think that it does have an effect sometimes on the board and on the courts as to how they interpret best wishes and the well-being of the parties. Ms. Holland's condition did indeed stabilize, though, and she left the ICU. and was returned back to her long-term care facility that she was residing at. It was at that point that Ms. Holland's medical team decided that they would consider the veracity of future ICU treatments with respect to Ms. Holland. As it turned out, Ms. Holland had a recurrence and she went back into the ICU. And then after the second time of being in the ICU, the medical staff, Dr. Hajra, hence the other name in the case, proposed to the substitute decision makers that further ICU treatments be withheld. And as such, the plan, of course, was to agree to, that's what they were being asked to do, would be agree to withholding future ICU treatment. It was not with respect to withholding all treatment. She was still going to be receiving all necessary painkillers and sedatives in dealing with her other medical circumstances, but the thought of the medical staff was that would allow her to succumb to her illnesses in a dignified manner. The two daughters disagreed with providing consent to that plan, and Dr. Hajra, under Section 37, which Marshall has mentioned is the section that doctors can apply to the board, did so apply, and sought a determination that the substitute decision makers were not acting in compliance with Section 21 of the Act. At the board decision, the board was held on October the 5th, 2003, and then a day later, the board rendered its decision directing both of the substitute decision makers to consent to withholding the next ICU treatment. The daughters appealed to the court under, I believe it's Section 80.81 of the Act, and that's how the case found itself before Justice Cullity. Now, the daughters, in appealing to the Ontario Supreme Court, the Ontario Superior Court of Justice, and therefore Justice Cullity on this case, were asking for a determination or a finding that the board had erred in its application of Section 21, and specifically finding that the substitute decision makers had not complied with Section 21. And they also raised a constitutional issue in that the provisions of the Healthcare Consent Act relating to the consent to treatment by a substitute decision maker were an unconstitutional violation of Ms. Holland's rights protected by Section 7 of the Canadian Charter of Rights and Freedoms. Now, while that was an argument and it led to two interveners being a part of the proceeding, at the end of the day, Justice Cullity did not address the constitutional issues, finding that given his finding on the case, it was, frankly, I think from his standpoint, better left to a different situation than the circumstances in this case. Following the hearing before Justice Cullity set aside the decision of the board and therefore the decision that the substitute decision makers were required to consent to the proposal by the doctor. The two interveners on the case were the Attorney General of Ontario and the Euthanasia Prevention Coalition of Ontario, and the EPCO, if I can use the acronym, was arguing the position that their concern was that it represented, that is the board's decision represented a significant step down the slippery slope towards professionally assisted euthanasia or mercy killing. So this case did have that context to it as well, where it's not just the family members and the board dealing with one another in front of a judge and the court. There were other groups that could intervene and have a say in the outcome. Now, before I get to what I would call the substance of the decision in terms of the best interest and how the wishes were treated, I do think it's interesting to note that in this case, there was an issue of new evidence being admissible before Justice Cullity that had not been heard at the board level. And that typically, if a matter was going to be appealed to the board, appealed from the board to the court, the only record would be the record before the board itself. But there had been an agreed statement of facts between the parties, and in that it came to light that Mrs. Holland's medical condition had slightly improved. So it had not decreased in its or deteriorated in its severity. It had indeed slightly improved. And Justice Cullity found that that was important because part of what the board was deciding was how a treatment may affect someone in the future. So in this particular case, Justice Cullity allowed the agreed statement of facts to come in and accepted that evidence as being relevant. The other thing that I'd like to touch upon as well at this point is the standard of review to be applied by the court when considering the board's decision. And that sounds like it's pretty technical, but it is important from the standpoint of how the court even views the board's ability to make reasonable decisions. And Justice Cullity confirmed that the standard of review to be applied to a decision or an appeal on facts or mixed law and fact is the standard of reasonableness, not correctness, but what was reasonable in the circumstances. And that with respect to an issue of law, the standard was indeed correctness. So if it's a matter of law that the board is being appealed from, the board had to get it right. And if the board didn't get it right, then the appeal is going to be allowed. But with facts or mixed questions of fact and law, again, it's the standard of reasonableness. Now, what does that mean? Well, Justice Cullity found that that meant, based on other decisions that had come before his, was that meant that deference is provided to the board when it comes to what their decision actually was. So if it was reasonable on the facts and on the facts and law together, the decision of the board, then the court won't set it aside. So the court, and Justice Cullity specifically commented on the type of specialization that Marshall was referring to that the board has. And as such, if the facts lead one to a conclusion that is similar on the basis of reasonableness to the board, then the appeal, according to Justice Cullity, won't be successful. Now, let's deal a little bit with the statutory aspect of Section 21. 21 initially says, in 21.1, I think it is, that if you know the prior patient's wishes while they were capable and over the age of 16, then the decision is to be made in accordance with those wishes. And then, if that's not possible, and it has to be applicable to the circumstances, and that's a key phrase in that part of the section, and if that's not possible, then you go on to the best interest case and test. And one of the questions that was raised earlier on the floor after one of the presentations was dealing with what are the factors. Is it just quantity of life or quality of life? And one of the arguments that was before Justice Cullity in this case was, what does the words well-being mean in the context of Section 21? Because as part of the best interest test, one looks at the values and beliefs, one looks at the wishes that don't fall under Section 21.1.1, which are applicable in the circumstances, and then it's also dealing with the well-being of the patient in certain of the, what I'll call the medical tests as Marshall was, or criteria that Marshall was referring to. Well, the doctors argued that well-being included considerations such as a person's dignity and levels of pain. It was the substitute decision makers in this case that were arguing, no, it doesn't extend beyond just the medical well-being. And that's because they, from their perspective, they wanted well-being just to be limited. Justice Cullity agreed that the word well-being includes dignity and levels of pain, and so not just a medical interpretation. And so that is obviously a factor in dealing with one's best interest. In a statutory provision interpretation on the part of Justice Cullity, he looked at Section 21.1 and said that the board erred in making a determination that wishes which were not applicable to the circumstances of the particular case were not relevant. In other words, the board had decided that on the basis of what was available in terms of evidence for the wishes of the patient, that at the end of the day, if they didn't fit into category 21.1, which were applicable to the circumstances, they weren't relevant. And Justice Cullity said, no, that's wrong, and on that basis alone, he would have turned over and set aside the decision. So that's where the board made a decision that was in error based on law. In dealing with the specific circumstances of best interest, Again, I've already commented on that wishes which aren't specifically applicable, that is wishes of the patient, that aren't specifically applicable to the medical circumstances at hand are still a factor that is to be taken into consideration by the substitute decision maker and those involved. And what is perhaps of equal importance is the values and beliefs of the individual patient are to be taken under consideration. And in the Scardoni case, the board held that while Miss Holland was a Roman Catholic and known to be a Roman Catholic, that the fact that she held the belief that the Roman Catholic Church would, as one of its policies, uphold the sanctity of life, that specific view was inconsistent in the board's view with what the actual policy of the Roman Catholic Church was. They found that the Roman Catholic Church, again, the board found that the Roman Catholic Church had no fixed guidelines regarding treatment at all costs for the purpose of prolonged life where there was no prospect of recovery. And the board found, therefore, that her personal values and beliefs regarding that were not relevant to the situation. Justice Cullity said, no, that's not right. A belief is a belief, and it's not based on the institutional beliefs. And if she felt that for religious reasons she wanted her life to be prolonged, and that was her hope, then that is a factor that goes in the consideration of best interest. And then just lastly, because I know I'm up against the time here, on a completely different note, Justice Cullity found that the board had erred in its understanding of the medical evidence. He acknowledged that it's extremely difficult for the board, having to turn around its decision in about 24 hours within one day to get it all right, but that's the standard. And if they are incorrect in their understanding of the evidence, then that alone is a basis to overturn the decision of the board, even if that misunderstanding wouldn't have changed the decision. And in this particular case, the board had apparently mixed up the understanding, or the evidence rather, that had been provided by the medical team based on various treatments, CPR, and the treatment that would have been had at the ICU. So the decision provides a number of different issues to consider, some procedural, some quite substantive, and some that are a little bit surprising when you read the decision, because you do come away with the thought, if you're not a lawyer, that, hey, the board can make a mistake. And the judge found that the board had made a mistake on a couple of different points and set aside the decision of the board. So I think with that, I'm at the end of my time.
Thank you, Craig. Professor Usteroff?
I think I'm the only person in this room who's addressed by an honorific. I always think that's kind of weird. I don't stand on any formality, and Ian knows that too. But yeah.
I'm just trying to bring a little class to the operation.
You're right. You're right. And Charles said the same thing to me earlier. You know, the funny thing is about being the last guy on the totem pole, I mean, the last person of the last panel to speak, is that a lot of these topics have already been covered. And that leaves one with perhaps not too many things to talk about. But since I'm introduced as a professor, I'll have something to say, regardless. First, a couple of housekeeping matters. The first one is something that my dear friend Kim Whaley volunteered me for in her presentation in the first panel, and that was about the Bentley and Maplewood case from BC. And the question there was, can a capable directive be overridden? And the answer to that in Ontario, of course, is no, it can't. If there's a prior capable wish, then the statute says that it must be adhered to. So the situation, therefore, is quite different in Ontario than it is in British Columbia. The second point that I wanted to make by way of introduction was another point raised by Kim. She referred to an article by Dr. Gordon in connection with the Friedberg and Korn case. I just thought I'd let you know that that has now been published. It's in the latest issue of the Estates, Trusts, and Pensions Journal, which I just got on Friday, so it'll be there for you to read. It's a very instructive article, and I think you'll find it useful. So with that, we've heard about the Rasuli and case, and of course the Grover case that is my mandate to talk about is somewhat different in outcome and also in approach. I'd like to give you first a bit of background facts. Mrs. Grover was an 81-year-old woman who was a patient in a nursing home. She had suffered 2 non-debilitating strokes, relatively mild. And after that, she was interviewed by the nursing home's physician about what her wishes might be for health care as she continued to be a patient in the home. She insisted on Code 4 treatment, which means full resuscitative measures. And then she signed the home's health care directive to that effect, and it included the statement, "Do everything possible to cure my illness and prolong my life, including heroic measures." Now, there have been some comments already about that infelicitous phrase, heroic measures, and I'm going to say something about that later on as well. Not very long after signing this directive, she suffers a debilitating stroke which left her in a non-communicative state and a functional quadriplegic. She was then transferred to hospital, put on life support, and that included the continuous use of a ventilator and an endotracheal tube. There was never any discussion with the patient about her wishes in the event of a life support situation, such as this 3rd debilitating stroke that she suffered. Her physicians came to the conclusion that some form of treatment plan ought to be proposed to the substitute decision maker, who was Mrs. Grover's daughter. They presented her with 2 alternatives. The first plan involved the withdrawal of life support, and that meant that if the patient was unable to breathe on her own, then she would receive only palliative care, so painkillers, that sort of thing. If she was able to breathe on her own, she would receive nutrition and hydration and be transferred to a long-term care facility. Her life expectancy in that case would be short. Now, the second plan, this full treatment plan, the Code 4 plan, if you like, would require a surgical tracheostomy and the insertion of a gastrojejunoscopy tube. Wonderful medical language, isn't it? We break our tongues over them, but somehow they manage. Anyway, this would be put into the patient's stomach and small intestine, and through it she would receive nutrition. Under this plan, her life expectancy would be less than a year, and she'd likely suffer complications from this treatment. The physicians recommended the first plan, withdrawal of life support, but the SDM insisted on the second plan, including heroic measures. Interestingly, there were 9 siblings of the SDM, and they disagreed with her. They felt that in these circumstances, their mother would not want her life prolonged in those circumstances. Well, in that situation, of course, the physicians had to apply and did apply to the Consent and Capacity Board for a determination, first of all, whether the patient had made a prior capable gift, and if not, whether the SDM had failed to comply with Section 21, in other words, whether she had failed to act in her mother's best interests. So the board found that the patient had not previously expressed a wish, while capable, with respect to her current condition. The board felt that the statements that she'd made in the nursing home and in the healthcare directive that she signed didn't address the possibility of a third debilitating stroke. And in that context, the board, and this was accepted later by the court as well, the board applied the dictum of Justice Sharp in Conway and Jacks, which is referred to in my paper, that prior capable wishes are not to be applied mechanically or literally without regard to relevant changes in circumstances. He said that those kinds of wishes have to be interpreted in light of the circumstances in which they were given. Now, the board held, therefore, that the SDM had to make a decision in the best interests of her mother under Section 21, and that she failed to do so. So the board ordered that she consent to the withdrawal of life support, but of course she appealed to the court, and as Craig has already mentioned, an appeal to the court does not amount to an appeal de novo or a hearing de novo, but it's an appeal on the record. However, the court may receive new or additional evidence, which was, in fact, took place in Scardoni, and the court may also exercise all the powers of the board, substitute its opinion for the board, direct the matter back to the board, and so on and so forth. But nonetheless, the appeal does amount to a judicial review. And that, as Craig also mentioned, is because the board has special expertise that the judge hearing the appeal does not have, and so the court must give deference to the board's expertise in that area, at least on matters of fact or mixed law and fact, as Craig already discussed. Only in the case of issues of law and statutory interpretation, the standard of review is correctness. Well, Justice Hawken, on the appeal, upheld the board's decision. The issue, of course, was whether the wishes that were inscripturated in the nursing home health care directive applied to the patient's circumstances, and if not, whether her best interests, what her best interests were, and then finally, of course, whether the SDM had complied with the statutory requirements. Justice Hawken, of course, applied the reasonableness standard, because the issue was one of mixed law and fact. He concluded, as did the board, that the wishes expressed in the nursing home directive did not apply because the patient had not considered the possibility of a third debilitating stroke. There was, interestingly, no appeal to the court of the board's finding of best interests. Justice Hawken distinguished Scardoni because in Grover the evidence was clear. There was no chance of appreciable recovery, and Mrs. Holland in Scardoni was not in a vegetative state, wasn't brain dead, and had improved somewhat since the board hearing, whereas none of that occurred in this case, and Mrs. Grover was in a non-communicative state and a fundamental quadriplegic. So the big question, I think, is, was this decision on the prior wish correct? I think we need to keep in mind that one of the foundational purposes of the Act, the main foundational purpose of the Act, and it's been referred to in earlier panels too, is the purpose of enhancing a patient's autonomy. Enhancing the autonomy of persons for whom treatment is proposed. And we do that by requiring that their wishes with respect to treatment be taken into account, be adhered to, if they were expressed while the patient is capable. And then, of course, if the patient was not capable, then you turn to the decision of the SDM, and she must make a decision in the patient's best interest. My question is, could it not be said that this patient, Mrs. Grover, had the possibility of a third stroke, a debilitating stroke, in mind when she signed that directive? Is it not the case that a person who suffers a stroke is well aware, is told by the physician, you know, it can well happen again, and it often does. But the point is, if that was the case, if she had it in mind when she signed that directive, is it then not a prior capable wish, and should it not have been followed? It's true, of course, that Section 21 sub 1 speaks of a wish applicable to the circumstances, and as we saw, that was addressed also by Justice Sharp in Conway and Jack. But I think that case is distinguishable, one, because it was dictum, and two, the circumstances in that case were quite different. In addition, as Justice Cullity mentioned in Scardoni, and as mentioned also by Craig, a wish that is not a capable wish in the circumstances is still relevant and must be considered by the SDM under Section 21. In my paper, I also review a recent case, Re A parentheses C. It wasn't within my mandate, but it came up as I was preparing my paper, so I thought I'd refer to it. Its facts are similar to Grover, and the board and the court reached a similar conclusion. Here there was no prior capable wish, but the patient had expressed wishes, albeit not very specific, but she had expressed them to her pastor. She was a very religious woman, and she had said to her pastor, I'd rather die than be bedridden for the rest of my life. The board and the court rejected those wishes because they didn't contemplate a life support situation. Question, could they have been interpreted another way? And if so, should they not have been honored? Now, in that case, it wouldn't have made any difference because the board or the court came to a conclusion that gave effect to the patient's wishes in any event. But my point here is that, and it's perhaps no more than a feeling on my part, that the board and the courts don't pay enough attention to those prior wishes. They almost shunt them aside quickly and almost as though, well, we've got an SDM and she can make the decision. I think we need to pay closer attention to these prior wishes and interpret them liberally if they're capable of different interpretations. Now, I conclude my paper with some suggestions about drafting powers of attorney for personal care. When these things were first introduced in Ontario, lawyers didn't know what to do with them, and that, of course, was understandable. They knew how to draft wills, but this was something entirely different, and it was medical stuff, and, don't really want to know too much about that. But perforce, they had to prepare them. Patients were asking for them. Unfortunately, the early powers of attorney ended up with words like heroic measures and such, something which, we should never use, because what was an heroic measure 10 years ago probably isn't today in light of medical advancements. But it goes beyond that. The point was made also by others earlier that we need to sit down with our clients and talk in greater detail about the possible medical conditions to which your clients may succumb as time goes on, and give them an opportunity to think about it. Let them talk to their family members, to their physicians, and get some ideas from them. And then, when they have reached some conclusions about the matter, then incorporate it. My view is that we should be more specific in our powers of attorney for personal care than less. I think it's only fair, first of all, to the SDM, but also to the rest of the family, that Mom was specific about her wishes. And then also, of course, there'd be much less of an issue to come before the board or before the court. In other words, then we honor the patient's autonomy already at that stage, which is the stage where we should be active. Well, I could go on, but as I recall from when I was still teaching, when it came the end of my time of the lecture, my students would get very restless, and they'd make it known that time was up. So I'm going to stop there, but there was one additional point. May I, Ian?
Absolutely.
There's one additional point that I wanted to make. What struck me during the presentations today, and some referred to it, Deb Stevens, for example, in her introduction, Blair Henry as well, is how we're dealing here with stories, right? Stories of family members, of patients, of clients. Their stories are all different. They're none the same. And we all have wonderful stories, undoubtedly, of family members, parents, for example, in the last stages of their lives. I have wonderful memories of my father. He lived to be 80, and the last few years of his life, he suffered from senile dementia, which of course is progressive. The last couple of weeks, he was hospitalized, but he was a man of strong faith. And while he no longer remembered us, and he didn't have memory of recent events, he remembered what he learned as a child. And those were the Psalms of Zion, in Dutch, because that's what he was. And he also had a wonderful bass voice. And he sang those psalms in hospital to the delight of the nursing staff and the physicians. Isn't that amazing? You see, there's a situation where there was no end of life issue. We didn't have to make any decisions. He was at the end of the road, and we knew it. We were waiting patiently until it happened. But nonetheless, there are those wonderful stories, eh? And you all have them. And these patients that we've talked about in the cases that we've discussed, they had them and their families have them. They're precious. Hold on to them. Thank you.
Charles, I think.
I'm back, and I'll try and be quick, but it's actually just the same question, but in a different way, about prior capable wishes. So just to, I guess, simplify it. So in the Scardoni case, so I guess this would be more to Craig, they use words like withdrawal of treatment and withholding of treatment, and they sort of, my understanding from the answer to my question before was post-Rasuli, if you have prior capable wishes, and assume they're clear and unassailable and unequivocal and as strong as possible that a drafter can make them, that only affects, there was a nuance added to my question by the person from Sunnybrook saying that's for withdrawal. Rasuli only goes so far. It doesn't go, you can't force the doctor to the treatment. But my understanding in reading the case, Craig, was that they were asking the board to say if they go into ICU, again, they can be treated. But why would they have to ask for permission for a future course of treatment that they could just simply not offer?
Well, one of the issues in that case was the same issue that was in Rasuli. But the way that Justice Colity dealt with it, as opposed to dealing with that specific issue, he in turn interpreted the fact that a treatment was proposed, and the treatment was to withhold further ICU treatments. The fact that the substitute decision makers were asked to consent to it, that the doctor took a step asking the substitute decision maker to consent to it, put it into Justice Colity's mindset, a clear plan of treatment.
Okay, so post-Rasuli, if the doctors really determined that they didn't want to do the ICU again, the better course from them, just from a legal perspective, would be not to mention it, not to propose it, and just simply not to offer it should she come back to the hospital. That's my reading of it.
I think that's clear.
Thank you.
The difficulty in these cases, at least some of the cases before Rasuli, is really understanding the wishes of the patient. Because on the face of what Professor Oosterhoff was talking about, and even in the Scardoni case, where everybody agreed this is what she had said, that she wanted where there's life there is hope, or where there's treatment there is hope, and she had these views that a person who is not sort of trained legally would think that is enough, and it simply wasn't. And it seems that, I guess I'm piggybacking on Professor Oosterhoff's comments there, that it's difficult to know how specific the wishes have to be, and that in the absence of having very specific wishes, to what degree do we allow a liberal interpretation of the wishes that we know that are undisputed, in terms of how far that's going to go with allowing those wishes to be adhered to in accordance with the first part of the test in Section 21.1, which means they have to be followed.
So just on that point, a religious client comes to you and says, I want to be kept alive under all circumstances. Would it be useful to say that even if I didn't anticipate a change in my medical condition, I still want to be kept alive? Or is there some magic wording that we can put in these personal care power of attorneys that will have that effect?
I'd say it's important not only to look for wording that would follow that client's wish, but also to ensure that client has a discussion with their substitute decision makers to make sure that what it means is what is written down. A lot of the times people receive the role of substitute decision makers by statute, or they even get a power of attorney saying they're supposed to make the decisions. But they don't, and they haven't had the discussion. So it would be important to do both. Put as close as one can to track that language in the power of attorney for personal care, but also encourage the person to speak with, importantly, the people that will have to make decisions if they can't.
Will that language work according to that decision of Justice Sharp? If you don't anticipate, and there's no way anyone can anticipate all medical conditions, then it's a whole new ball game. It's open to the court to reevaluate if something changes between the time the power of attorney was exercised, and we all know there's always a change in conditions. So how do you protect against that? Okay, you discuss it with your SDM, but is there magic wording that we can use?
There's no magic wording that requires a health practitioner to provide services that the health practitioner isn't going to offer. So it can only go so far, but certainly one can communicate that wish and in writing and verbally and get as close as one can to any treatment that is offered continuing.
If I can add something to that, I think it would undoubtedly be useful, important in the power of attorney also to detail the person's religious affiliation and her own personal beliefs, because of course they could potentially differ somewhat from that of her religious affiliation, and then from there segue into "and therefore I want," right? Something like that.
Thank you.
We've come to the final segment of thanks, and on that note, if I could call up Frank Diamond, our Chief Executive Officer of B'nai Brith Canada and the Foundation, to make the final presentations and the thank yous. Charles, you'll present with him.
I know that everyone's been very patient. I know that I have to review my will and testament now. I know that. I want to thank the sponsors. I want to thank the panelists. I want to thank Charles. Without Charles, it simply wouldn't happen. The kind of energy that he gives to this program, it's just remarkable. And we're so thankful to him. To Anita, I want to say thank you. This is the last year that Anita will be doing this with us. Some of you may be reading very shortly. She's been appointed the National Director of the Race Relations Foundation of Canada. So we're delighted that this is the second staff person that has held that position. So we're really delighted, and we wish you all the best. And there is a winner here that we have to announce.
Yes. Mr. Lichtenstein?
And what are we going for?
A custom shirt.
Frank Diamond. No, here we go. It's Steve Notice Investors Group. So come on up. Yes, there you go. You will have the card. And now it's a pleasure and an honor to call on the man who's been giving out all the awards today. And I think they were so well received, Ron Ellis. All yours.
All mine? All yours. You get up here, you rascal. We'll do this together. Okay, no problem. Anita? The first person I'd like to call up is Ron Ellis's most favorite fan. I'd like to call up John Clegg from the Bank of Nova Scotia Trust Company. Ian, if you come down and join us, please. Mr. Swadron. Craig, come on down, please. In Hebrew, there's a saying, Acharon, Acharon, Chaviv. Our last is our most dear. Professor Oosterhoff, please.
What's that again, Charles? Acharon.
Acharon, Chaviv.
Chaviv. You see, because I'm Dutch, I can do the ch sound.
Professor? Nice to meet you.
Thank you so much.
Well done. Great panel.
Thank you very much, all of you, for coming. Until we meet again next year.